Okay, now, let's talk about some cases. The cases that have so far been this year, it hasn't been a lot of really terribly interesting cases, but there are some that possibly will come up. The most interesting case that has been accepted won't be heard until October, or for the October term, which is the Second Amendment case. Now, let's talk about the Second Amendment. The Second Amendment is the one about gun rights. And in the Heller case in the District of Columbia, the Supreme Court said that the Second Amendment applies to individual rights, not only people who are in a formal militia. Well, when the Supreme Court decides something, one of the amendments and how it applies, that applies to the federal system. And then the states say, well, that's the federal system, that's not us. So they had to go to Chicago and do the McDonald case, where the court said that we are going to selectively incorporate, is the term, the Second Amendment through the 14th Amendment to the states. So it's now to the states. Now what's happened, because of the way those opinions were written, it left wide open the ability of the states to do restrictions on gun rights. And so in some, like District of Columbia, New York City, etc. So now they have accepted, the court has accepted, granted cert on a case of the Second Amendment dealing with the scope of these restrictions. In New York, for example, there are two types of weapons permits, pistol permits. You can have a carry permit, only people that get that are famous or have a lot of money, stars, etc. And then there's premises permit, where you can keep one at home. With a premises permit, you can take that gun with you to a shooting range to shoot, but it has to be within the 5 boroughs. You can't even go outside the 5 boroughs of Manhattan. That's against the law. It's a criminal law. So that's obviously being challenged. Makes no sense at all. There's a lot of talk about, California's passed assault weapons bans. If you read the assault weapons law that finally lasted for 10 years and then expired without being renewed, the definition of assault weapons is just ridiculous. It has no bearing whatsoever. It focused on physical appearance of rifles as opposed to their functionality. Semi-automatic weapons fire once every time you pull the trigger. They also call autoloaders. You don't have to put a cartridge in each time. There's a magazine that feeds every time you pull the trigger. Fully automatic means when you pull the trigger and hold it, it'll just keep on firing. Fully automatic weapons have required special licensing under the National Firearms Act since the 1930s. This is not something new. So what they're trying to ban is things like the AK-47 or AR-15. The AR-15 is a semi-automatic version of the M16 from Vietnam era. And, they're semi-automatic. They're not fully automatic. They had, if you have a pistol stock and a flash suppressor, that's now an assault weapon. Made no sense. So people in the gun community, such as myself, started calling these rifles that were called by Feinstein and Schumer and Durbin and all those guys, we call them evil black rifles. And there are books about evil black rifles, and it's sort of a sick joke. So the Second Amendment case is coming up. That's been granted. Now, I mentioned to you about the Kelo decision. I call attention to the Kelo decision. This was possibly the worst decision of the Supreme Court in the past 20 years. Mrs. Kelo had a little pink house. I think it was in Connecticut or Rhode Island. And New London, okay. And she was in a waterfront area that had sort of fallen on hard times. And the local community, the local metropolitan municipality said, we want to use the power of eminent domain to take your house and give it to a private developer who's going to develop this whole area, and it's going to benefit the community. So if you look at the Fifth Amendment to the Constitution, which is on page 32 of the handout, no person, blah, 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 can be compelled to tell, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Now, up until Kelo, what that meant was public use was, you need to build a school, you need to widen a road, you don't build a park, okay, and then you get into a fight over the state or the municipality hires an appraiser and they lowball you, and then you hire an appraiser and you go to court, and it's one of the few cases where you can get a 12-member jury to decide what the real value is, and you lose your property. So Mrs. Kelo lost her property, was paid, whatever. They turned it over to a private developer that immediately left the scene, went down the tubes. And Mr. Justice Kennedy was the deciding vote in Kelo, and it's probably the worst decision in 20 years, at least. Terrible, terrible, terrible decision. There's no way that you can justify now. So what happened with Kelo, what did Kelo generate? Kelo generated in the states. Kelo generated state action. So what we have now is on November 7, 2006, we adopted a constitutional amendment, Article 12A, no part of a person's property shall be taken by eminent domain and transferred directly or indirectly to another person if the taking is for the purpose of private development or other private use of the property. New Hampshire Constitution. Okay, a lot of states have adopted similar things. So today, Kelo would not happen in most states, but whether or not, I'm sure there's some states left that still haven't adopted something like this. Maybe something like that will get there. Roe versus Wade, that's the abortion case. Okay, I have a deal to make. We've got a small group here, and I'm Jewish, so I'm going to have a $20 bill, and I will award the $20 bill to anyone who can look in the Constitution and point me to the word abortion. Wait a minute. I'm Jewish. I'm not that cheap.
It's not there.
How about a $100 bill? Find the word abortion. I checked before, obviously. I'm not going to be stupid. It's not there. Look, also, same thing. Help me, $100 bill. Where in the Constitution the word privacy appears? Not there. Okay.
Hunting doesn't show up in the Second Amendment either.
Well, what happened? It doesn't show up. I did a just to make sure I wasn't going to be giving away too much money tonight. I did a scan before I left to scan the text of the Constitution amendments just to make sure that they're not there. Now, what happens is, and I'll give you my take, as a Federalist, and I'll tell you why some of these things happen. Where Roe versus Wade came from. Roe versus Wade and the concept of privacy, individual privacy, which is not mentioned in the Constitution, came from a 1965 case in Connecticut. And what happens is when government starts getting involved in areas that are not proper government functions, mischief is what occurs. And so what happens is Connecticut adopted a law, the Connecticut legislature, very smart people, adopted a law criminalizing the possession and the dispensing of contraceptive devices, including condoms. Makes a lot of sense, right? Well, so it went to the Supreme Court of the United States, and in 1965, and Mr. Justice Douglas, who is now deceased, well-known liberal, was the one who wrote the majority opinion, and he talked about a right of privacy. He created a right of privacy. And the right of privacy, okay, he talked about in terms of, here's a light, here's an object, and you get a shadow. The dark area of the shadow is called the umbra, and the gray area, before it gets to be full light, is called the penumbra. The umbra and the penumbra. Mr. Justice Douglas says, the foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. So, the penumbra is what outlawed the Connecticut contraceptive law, and he goes through and discusses the right of privacy. And that's where it arises. In 1965, that's where the right of privacy comes. Then you get Roe versus Wade, and Roe versus Wade may come back again. Before Scalia died, there was scuttlebutt that he had, the intellectual basis for Roe versus Wade's decision is really poor. The jurisprudential intellectual basis, very bad thinking, very muddled. And Scalia thought he was close to having 5 people that would agree with him to review it, see it again, and change the view, leaving it up to the states. But that hasn't happened. Whether that will happen now, you can bet your bottom dollar that if the court changes the composition to be really more conservative, that Roe versus Wade may be relooked at. But I don't know. You know, all the people who are going up for nominations before the Judiciary Committee say it's like a litmus test now. Do you think that Roe versus Wade is the settled law of the land? They say, oh yes, it's the settled law of the land. Stare decisis, meaning the decision stands. But what stare decisis means, the decision stands until 5 people decide on the court that they're going to change their mind. So that's what stare decisis really means. So that was Griswold. Now, what else we got here? We talked about umbras and penumbras. And, okay, let's talk about Chevron and our deference. The first legislation passed, the New Deal legislation was passed by the Congress under Roosevelt. The first ones were deemed unconstitutional. What's the basis for a lot of these intrusions into everyday life in the states? Well, all this stuff, all this legislation, and all of the expansion, the establishment and the expansion of the administrative state comes, let me find you exactly the reference, and okay, in Section 8 of Article 1 it says, Congress has power, and it defines the powers, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcy. And then it says about patents, constitute tribunals inferior to the Supreme Court. And then it talks about things affecting interstate commerce. And so on the basis of the Interstate Commerce Clause is where the court changed its views, and between the Commerce Clause and the threat to pack the court with liberals, they changed their views and they said, oh, okay, under the Commerce Clause, we can regulate these things, even though some of the activities take place only in one state. So right now, for example, let's say you're a bookie in New Hampshire, and all your customers are in New Hampshire, and they call you. Let's say you live in Guilford, and they have all your customers as a bookie, all the bettors live in Guilford. They dial your phone number. They don't have to dial 603. They just dial the 7 digits. They call you. They place the bets. Everything else. Is that subject to federal regulation under the Commerce Clause? You bet your ass it is. Yes, because when you dial that number, the courts have said, yes, it could go right through the local exchange, or it could be going across the way up to the satellite around here. Everything else, it's interstate commerce. That's the basis for the expansion of the Commerce Clause, the establishment and expansion of the administrative state. What the Chevron and our cases said is that if the Congress passes a law that delegates to an administrative agency a certain area of expertise, and it's not explicit about what they shall and shall not do, that the courts should defer to the judgment of the bureaucrats in the agencies. And those things have been, that deference has just been awful, as you can imagine. So that's being primed. Hopefully we'll get some good cases there. Obamacare, we don't know what's going to happen there. Depends on the composition of the court. But okay, so.
Croc TV.